Thank you, Madam Clerk. Welcome, everyone. This is our afternoon session. And for those of you who weren't here earlier this morning, my name's Robert Wiedemeyer. I'm from Nashville, Tennessee. My colleagues to my right is Judge Jill Barty Ayers from Clarksville, Tennessee. To my left, John W. Campbell Sr. from Memphis, Tennessee. Each side has 20 minutes to argue. Actually, I'm looking out there, and there are a couple people who weren't here this morning. I've been a little repetitive, I guess, but each side has 20 minutes to argue. If you want rebuttal time and you're the appellant, please reserve that and when you come up to argue. And we have read the briefs, so you can tailor your arguments around the idea that we're well prepared with regard to the briefs. In some cases, we may have looked at the record, but in others we may not have yet. So let's call the first case, Madam Clerk.
Terrance Holliday versus State of Tennessee.
Mr. Tootin?
Yes, officially good afternoon.
You've got 4 cases all on one day today. So my theory is that you must have a friend in the clerk's office to make that happen for you, that you bring them donuts or something. What do you say?
No comment.
Okay. Excellent response. All right, go right ahead.
Yes, and I'd ask for 3 minutes rebuttal.
Certainly.
This matter is regarding Terrance Holliday, in which there was a post-conviction hearing that went forward, and ultimately the hearing was denied, the petition for relief. And we're here for 2 issues. One, because it's our contention that the petition should not have been denied, and then 2, the petition should not have even been heard by the trial court because there was a properly filed motion to recuse prior to it being heard that, quite frankly, should have been granted. Before getting too much into that, as the law is clear, I've cited in the brief, that the issue or the standard that we are reviewing this under is whether or not the trial court had any doubt as to whether their ability to preside impartially or whether their impartiality could be reasonably questioned. And I think either of one of those 2, I think you have to fall into one of those 2 under the facts of these allegations. So the first thing that occurred, or one of the things that occurred, is I filed the motion to recuse, which is not something I enjoy doing or make a practice of doing. I don't really take hardly anything personal. The youngest in my family, I've been yelled at and got on a lot of people's nerves. It's not something, I have very thick skin, but only when I believe I have to for the client is when I even engage in these types of things. But it was filed on June 13th of 2023, I believe. The date of the hearing was June 22nd, 2023. So one of the issues that I raise is that the trial court threatened to hold me in contempt. Quite frankly, the trial court, I had another attorney from my office appear, and they said, nope, I want Mr. Tootin to personally appear. If he doesn't show up, I'm holding him in contempt. Did not know where that came from or what the basis was of that. That was reported to me as I put in the motion by the colleague who worked with me as well as the deputies in the courtroom. I raised that in the motion because, again, even if that wasn't personal, the appearance is not very good based on the way that everyone that I'm coming into contact is reacting to those statements. Well, the court never addressed that allegation in the order denying the motion to recuse. However, and I understand opposing counsel's argument now, the argument is, which again, even the trial court didn't make the argument, opposing counsel's argument is, hey, that language is not clear. The judge categorically denied everything, so it's not even clear we know exactly what date you're talking about or time you're talking about. The court specifically stated in volume 2, pages 12, line 24 to page 13, line 6 is the area, but specifically page 13, line 4, when referring to that allegation, the court says you weren't here that day. So this is not a question of the court saying, I have no idea what you're talking about, Mr. Tootin. It's, okay, well, that's technically hearsay and it doesn't apply because you can't rely on that. And I believe the order specifically said I can't rely on representations I don't have personal knowledge of. However, when the court is the one making the communications and it's the exact same court addressing it, The court, at a bare minimum for appearance purposes, could have said, and by the way, Mr. Tootin, I hate that that was referred to you that way, but that wasn't accurate. Or it was said in this context because the way you're saying it is not accurate.
Mr.
Yes.
Let me, just because I'm a little confused. You refer to the statement of the court, but I don't remember seeing anything in here where there is a transcript of where this threat to hold you in contempt was
Correct.
ever.
And that is correct. That, it is alleged in the motion, and then the court rules on it, but there is no transcript. There was no transcript. There was not, and again, opposing counsel is right, there was not a date provided. I relayed the information as I knew it to put the court on notice. The point that I was making in the motion, Your Honor, was to let the trial court know there is at least an appearance now, because when this is being reported to me by my associate, by deputies, I don't even know if it's true. I admit I wasn't there, but this doesn't look good. It doesn't sound good, and it's coming from multiple places, and I would have testified under a stack of Bibles or whatever. This is what I'm being told, and if you want to have a hearing to clarify that, please do. And when your only response is, well, I'm not going to address it because you don't have firsthand knowledge, or saying you weren't here that day, as opposed to saying, well, let me clear this appearance of impropriety out there, that's not true. That was an easy fix to say, look, I don't even need a transcript of a date because I would have never said that, I would have never done that, or if it was said, it would have been taken out of context. Something to put the appearance at ease. That did not occur. But I had to, as an officer of the court, represent to the court, this is what I'm being told, this is who said it, and we need a hearing. They can tell you the specifics. I'm just telling you, when this is being presented to me, and my client is being made aware of this, it doesn't look good, it doesn't sound good. In court, you need to know that. So for that not to be vehemently opposed or countered in a meaningful way is where the appearance, because again, I understand your point, Your Honor, is that, well, where is it specifically? But what I'm talking about is the appearance. I don't know if it happened. I believe that the deputies and my associate would not misrepresent that to me, but I don't know. And I'm not going to tell the judge, you did this. I'm going to say, this is what I was told, and this is the appearance it creates. In addition to that, this goes to a case that I argued earlier. We're having an issue because at that point, again, it was June 22nd, 2023. I had previously had a post-conviction hearing of Carlos Key, and this post-conviction was dismissed without a hearing, and there's an order reflecting May 19th, 2023, which I argued that was not the date that this thing would have been entered. I do not agree that that occurred, and I believe that that date was not an appropriate date, and that date should have been corrected. And when there is an appearance that the court is entering dates that simply could not have been accurate, and then denying a post-conviction without a hearing in addition to that, and then entering order that I ultimately found out, because even at that day on June 22nd, 2023, I had not seen the order. But then we ultimately find out that that order lacked specificity or substance. So in other words, it's dismissing a post-conviction petition, claiming it lacks specificity in an order that lacks specificity, and somehow that order that lacks specificity took an extremely long time to enter. All of that doesn't give an appearance that that matter was actually considered fairly or impartially. Again, so that was the basis, part of the basis of the motion to recuse. Specifically on page 13 of my brief, where I'm actually talking to the court and it's citing to the transcripts, it says that order was not made available. This is me on June 22nd, 2023, referring to an order stamped May 19, 2023. I checked the system yesterday, and the system is showing now that there's an order. Then I go on to say, the system is reflecting one order was created May 19th and another one June 20th, because the client had two different case numbers. And for some reason in the system, they actually put in, someone put in one date of May 19th for the one order, and then June 20th on the other order denying it. But we only get one order denying both cases together. So again, I'm making it clear to the court, this does not look good. The appearance is not great, and there's significant concerns there. The trial court itself said that's probably the date I heard it, May 19th, which I agreed with. That is true. And then it went on to say, and I put is later down there, and when I had it done around judicial conference, which was not May 19, 2023, she went on to say, I didn't have a clerk available, making it clear it could not have been entered because there wasn't even a clerk available. And then I tell the court, well, that goes to my point. If we all agree that this date is wrong and it dismisses a matter without a hearing, and I was not provided that order, and you're now telling me as a trial court you agree with that, then why is it still representing that day? Why is it not being fixed? This goes to my issue. And so what the judge was arguing was, it was part of the bigger argument of why wait till today, June 22nd, 2023, to raise these issues? And I was explaining, it's not that I waited to the last minute. This is still ongoing. And in addition to that, I filed this on June 13th, 2023, not to today. The reason that is also important is because we then go on to have a discussion where she denies the motion, and I also cite to the transcript where she talks about she's going to be in trial the week of June 5th, and she'll continue to work on it, showing that at least as of June 5th, we know that it was not created as well. But I went on to tell her, or we went on to discuss with the court, that I want an order. I want a written order entered because I believe I have a right to one, so it can be appealed. There's a written order entered, and it's dated June 20th, 2023, as if we don't have enough problems with these dates, 2 days before the hearing of June 22nd, 2023. Now, opposing counsel makes the argument, it is appropriate for a judge to sometimes dismiss a matter prior to a hearing. The problem is, the trial court isn't even making that argument. I asked the trial court to have an order entered, and the trial court specifically said that I filed the motion, or they believed I filed it on June 22nd, 2023. That's volume 2, and that's page 5, lines 5 to 6. So in other words, the court is acknowledging they saw it for the first time June 22nd, 2023, and they believe that I filed it June 22nd, 2023. So that is against this narrative that it was actually an order denying me entered 2 days before the hearing when the judge didn't even know it existed. And then I followed up and asked the court for a written order. This is on volume 2, page 9, and I was told that I'll get it. And I turned around and said, I need one for appellate purposes, and I was again told I'll get it. Not that one already existed and I did it 2 days prior. It was I'll get it as in I'll create it and give it to you. So if this order really existed on June 20th, 2023, at a minimum, the trial judge should have said that or offered it to me. Instead, they say something completely different, which is consistent with it being created later and then the date being backdated. But at a minimum, it's consistent with there being a concern or an appearance of impropriety when this is yet another example of another post-conviction in front of the same trial court with, if not the same, I would at least be extremely similar issues of what's occurring, which again goes to what a reasonable outside party would think of when they're watching this from the outside. And they see that I'm alleging, Judge, you threatened to hold me in contempt. And the judge doesn't say, that's not true, or doesn't address it, doesn't clarify it. When I say, well, Judge, this order is dated May 19th, and it dismissed my client's post-conviction without a hearing, and that order didn't exist that day. And the judge actually agrees and says, well, look, it was around judicial conference, and all of this is happening, and then there's an order denying me that's entered 2 days before the argument even happens, and the judge never represents that she actually created it 2 days before. This disqualifies, in my opinion, the trial court to have even heard this post-conviction, because no one could feel comfortable from the outside looking in to see this and say, yep, justice is definitely occurring in Shelby County, Tennessee. It would bring very big concerns to anybody, not just me from my client. You all know that I'm very avid, passionate, and would argue for all my clients, but you could take me out the equation and put anyone in. Everyone should have a concern with these optics. So those are the things that, and again, it was nice. I appreciate the argument the state made in opposition, but even the trial court didn't make the argument. Hey, by the way, Mr. Tootin, I actually ruled on this 2 days earlier. Here it is. So again, those are very concerning things. Now, as it relates to the post-conviction itself, it goes back to an issue where this was a murder case, very significant allegations. And there was a video, which of course the appellate we're alleging was extremely material. This was the incident. The video captured parties going in and out of a location right before the murder occurred. The murder was on, I believe, a strip mall where this location was right next to it, where I believe a weapon would have been used to, I believe the weapon was left in the bathroom, and the allegations is at a place next door that was then used the crime was committed and left. All that to say, the individuals on the video and the timing of this video was extremely material and significant. Prior to the hearing, the state stipulated that the video was never produced to trial counsel and never made available to trial counsel. Trial counsel is also appellate counsel, so I'll briefly touch on that issue while I'm thinking about
Wasn't
it.
the video actually lost? It never got tagged properly or
So
something
it
along
was,
those
so the
lines?
issue was it was tagged in the evidence. Well, it was collected in the evidence and never tagged, is my understanding of how the state described the issue. So the state had it in its possession, the state reviewed it, they took notes they represented to be from the video, and then those notes were provided to me during post-conviction, but it was never provided to the trial attorney, who was also the appellate attorney.
But
So-
didn't the trial attorney testify that he went to the store or the location where the video was and looked and realized it wouldn't have shown anything firsthand?
No, I disagree. I believe the opposing counsel makes an argument similar to that. So I believe the transcript will show that the trial counsel said, I don't know what it would have showed because I never got it, I requested it.
Well, I think he admitted he didn't see it, but that
Correct.
he did go to the store and look around, or I keep calling it a store, wherever it was.
Yeah, I understand.
And look to see what it might have shown.
Well, the problem is it showed
Did he
actual
do that?
witnesses. My understanding, now, I don't want to misrepresent that. I don't know if he did that. I know that he looked into this issue and tried to investigate the issue. But as it relates to what was on the video, the representations, even on the notes on the video, it was showing people that was going, like, it appeared to have been describing individuals who may or may not have been involved with this crime. It didn't, in other words, the video never came across as insignificant or having no substantive basis.
But the lawyer testified, the trial attorney testified that after he went and looked at the scene and where the camera was, he concluded that it wouldn't really add anything because it didn't show the shooting event.
Correct.
And he made the decision that he didn't think it was necessary or important, so he didn't file a motion, he didn't do anything about Ferguson, he just felt like it was just not going to be of any benefit.
Well, my position, and again, and I'll let the transcript speak that, I understood him to say that he didn't know what it would be because he had no idea what would be on the
He didn't know
video,
what
but it
would be
did not
on it.
show the shooting.
But he didn't know it would be on it, he just said it wouldn't be showing the shooting, what
Correct.
happened at the time of the shooting. And
Correct. It would
Based
not
on where
show-
the camera was.
It would not show the shooting, and that is undisputed. Our position is it definitely shows actors and parties who would have been right there associated right at the time of the shooting or near the time of the shooting, because the brief then goes out to point out how how trial counsel explains all the issues with the state's evidence, credibility issues of the witnesses and things of that nature. And even the state conceded and acknowledged that a jury instruction was available to the appellant based on the video being lost or destroyed. That's in volume 3, page 56, lines 24 to 25. So I don't believe there's a real genuine argument that there shouldn't have been a request or that it would have never made a difference. The trial counsel was adamant, I never know because I never received that information, even to this day. And I believe, just briefly, the opposing counsel makes the argument that to the extent that there is an attempt to attack appellate counsel, believe the argument is waived because it wasn't raised in the petition, and we respectfully disagree. The petition attacks his counsel as ineffective counsel, which is appellate and trial. It's both, and the same attorney represented him in the trial and appellate level. All right, thanks.
All right, thank you.
First, to the recusal issue, there's been a lot of discussion about the date the court entered an order in Carlos Key. That is an unrelated case. It's not part of the record in Terrance Holliday. And the date that the court entered the order in Carlos Key has no bearing on the court's impartiality or partiality in this case. And one thing I would point out, just for whatever it's worth, the court in the transcript here did reference May 19th as being the date that it entered the order in Carlos Key, and that is the date that the order was file stamped. But what's most important here, the post-conviction court considered the allegation that it was impartial based on its ruling in the Carlos Key case. It addressed that allegation and concluded it didn't warrant recusal. It addressed all of the petitioner's allegations. It said that it had considered them and that they were without merit. And There's just nothing here that the post-conviction court did that would have caused a reasonable person to have a basis for questioning the court's impartiality. And the petitioner focuses a lot on this alleged threat to hold post-conviction counsel in contempt. We don't have anything to support that that threat was made in the record here, but even if there was, even if the trial court made that statement, the Court of Appeals has explained that simply threatening to hold an attorney in contempt is not grounds for the court to recuse itself. I mean, if it was, then a court could never try and maintain control of its courtroom. Otherwise, it would have to recuse itself. And here, the fact that that statement may or may not have been made, it just doesn't show that the court lacked the ability to be impartial. And then there was some discussion about, I think, sort of the court's rulings in other cases that, in addition to Carlos Key, one of the issues here was that the court didn't address all of the allegations that the petitioner made, but the order shows to the contrary. The order shows that the court considered all of the allegations that the petitioner made. And since there wasn't a basis for someone to question the court's impartiality, the court properly denied the motion. And I know there's been some discussion too about the date that the court entered its order denying the motion to recuse. The fact that it happened 2 days before a hearing does not, again, give a basis for questioning the court's impartiality. There's no requirement that the court hold a hearing on a motion to recuse. The only thing that the rule specifies is that a court shall promptly rule on the motion, either granting it or denying it, and that's what the court did here.
So ruling before you have a hearing is pretty prompt, I guess.
Yes, Your Honor. It is
I mean,
pretty.
you have to admit that's a little odd to have an order entered. I mean, are you agreeing that's what the record shows, that the order was actually entered before a hearing was held?
It does, Your Honor. There was a 2-day difference, I believe.
That's just a little unusual. Agree?
I can understand that. I know it is a little unusual to have a lengthy and thorough order entered before there's a hearing, but in this case, since the hearing wasn't required, this very well could have just been the trial court extending a courtesy to the petitioner to give them another opportunity to try and make the case for why the court should recuse itself. And what's significant is that there wasn't any proof presented at this hearing. There weren't any new arguments made. There was nothing that the court basically didn't consider. It considered everything that it considered in its order was what was discussed at this very short hearing afterwards. And I think what this really shows is just that the court is trying to promptly dispose of this motion. And once the court did rule on the motion, it properly held a hearing on the post-conviction petition and properly denied post-conviction relief. Both Judge Ayers and Judge Campbell, you referenced the testimony of trial counsel. He did testify that he went to the store, the tobacco store, and determined, based on that investigation, that the video would not have shown the shooting. And that was on page 13 of volume 3 of the record. And once he realized that the video wouldn't have shown the shooting, he testified that he made a strategic decision not to file a Ferguson motion, requesting either a jury instruction or to dismiss the case. And that was made based on his reasonable investigation. He'd gone down to the scene and was able to confidently determine that the video wouldn't have shown the shooting, so it's unclear what would have been on the video. It's certainly not something that would have benefited the petitioner necessarily. And so counsel didn't see a reason to file a motion that he wasn't going to win. And I know there was some discussion too about the state conceding that a jury instruction was available. I think what the state was doing there was acknowledging that, yes, a jury instruction can be a remedy for a Ferguson violation. It was not conceding that there was a violation here and that the petitioner would have been entitled to the jury instruction. So I just wanted to clarify that. That was, I think, coming from a comment that the prosecutor made during the post-conviction hearing. But again, even if counsel had filed the motion, the petitioner has not shown that he would have succeeded on that motion because the evidence here just is not substantial. It wouldn't have been expected to play a substantial part in the petitioner's defense because, again, it didn't capture the shooting itself. It wouldn't have shown the crime. And that's what really distinguishes this from evidence like the dash cam footage in State versus Merriman, where our Supreme Court said that captured the criminal offenses as they were committed. It's therefore very significant. That's not what we have here. We don't have a video that would have shown the offense. And then what we do have, though, is two witnesses who saw this, four eyewitnesses actually to the shooting, two of whom identified the petitioner. And then a third witness provided a motive for the petitioner to commit the shooting, saying that it may have been in retaliation for an earlier robbery at the hands of the victim. And so all of this secondary proof would have come in regardless of whether the video was turned over to the defense. And the lack of the video did not reduce this case to sort of a credibility determination that otherwise would not have existed. And so because that video would not have shown the shooting, it wouldn't have helped the petitioner's defense, and he therefore cannot show any deficient performance from trial counsel or any prejudice. And unless there are any further questions on these issues, we would ask the court to affirm the judgment of the post-conviction court. Thank you.
Thank you, General.
I will start by finding something I do agree with opposing counsel since I disagree so much. Opposing counsel stated that the order dated June 20th, 2023 shows that the court was trying to promptly dispose of the motion. Agreed. Promptly disposing of it was exactly what was trying to happen, but also remember in what I've argued previously and which is supported by the record, the trial court didn't even know I filed the motion prior to June 22nd, 2023. So because one of the issues that the trial court was contesting is, why did you wait till today, the day of this hearing, to file the motion? So that necessarily means that on June 20th, 2023, they did not have an order written based, if we're taking trial court at its word as to what it was saying. That would be the only logical reason to say that to me. And again, simply threatening to hold an attorney in contempt in and of itself is not enough because again, attorneys can push the envelope. The problem is threatening to hold an attorney in contempt with no basis, and then when confronted with that and say, look, this was reported by these sources, and then you say nothing, in addition to the other issue with the other case that also has issues and discrepancies with dates, is a concern, and it at least goes towards the appearance. I believe opposing counsel, if I'm understanding his arguments, he's making arguments to say, and this is why I don't believe there's an actual bias. But the problem is I didn't hear any arguments that says there's no appearance of an actual bias, or at least an appearance of bias. And I believe we're all in here reasonable. If I could take a magic wand and change the rules, I'd say let's do a show of hands with everyone in here. Does this look reasonable? And I think I stand pretty good odds that the reasonable people in this room would say something doesn't look reasonable about what we're seeing and hearing from you. And so I think these are the concerns that we're raising. And again, as it relates to the trial counsel's statements and what he was saying, it's important to note that the trial counsel did say and acknowledge that there were credibility issues with the witnesses, that the evidence was not, basically trial counsel was saying there was no slam dunk evidence, that there were concerns, inconsistencies with the photographic lineup was another issue. And that when you're saying these things, you can't simply say it would have made no difference. And the last point I'll make is, because I've heard it argued oftentimes, and I guess I'm on my little soapbox here, and I'll get on my little 30-second soapbox and say, it's always disheartening when we know that evidence was not made available to the defendant, who they're fighting literally for their life. And then after they jump through all these hoops and they go through all these blood, sweat, and tears to be able to present proof to show that the evidence genuinely was not made available to them, then the fallback argument was, oh, well, it never made a difference or wouldn't have made a difference anyway. But it obviously made a difference enough not to provide it to them. And so it's a little disingenuous. But we'd ask that this matter be reversed. Thank you.
All right, thank you. Just to clarify, a minute ago, I just meant it was probably convenient for you to have all your cases on one day today. I wasn't implying that you were attempting any shenanigans with bringing donuts to any particular clerk, because I'm sure you would have. Anyway, I just don't want to be misconstrued in any way, and I appreciate your zealous advocacy on behalf of your clients, too. All right. Nothing like over-explaining things. That's what I've started to do as I get older now, so. All right, call the next case, please.
State of Tennessee versus Juan Deshaun Hoyle.